2014-168, State of Arkansas versus Robert Weaver.
Is here today on a reappearance. We're close to a plea resolution, Your Honor, but at this time, I have requested Mr. Kincaid, and I would request to the court that Mr. Weaver's bond on all the cases pending before this court be lowered to $5,000. Professional.
Judge, we have one issue of restitution which we can't get to make a plea on this case, and I think the bond reduction would be in order. There's about $2,000 worth of restitution that has not been resolved at this point. Perhaps if he gets out, he can earn enough money to make that happen.
All right, I'm reducing the bond and pursuant to that recommendation to $5,000. Obviously, the bond will be conditioned upon the standard conditions of no violation of law, etc., no use or possession of alcohol, and also it'll be or drugs. It'll also be conditioned upon not being around the place where this alleged burglary took place. So it's in essence a no contact order as a condition of that bond. The next appearance in court, according to the court's review of the records, is October 23rd. We have an appearance to check status of the case.
Thank you, Your Honor.
2014-203 and 2014-137, State of Arkansas versus Brandy Vandenberg. Ms. Vandenberg,
yes.
You're appearing at this time for purposes of changing your plea in both of these, in both the case where you're currently charged with escape and theft of property, and in the case that was filed as a revocation. Is that correct?
Yes, sir.
Mark, she needs to move to the microphone.
You need to
Yes,
speak
sir.
up.
And this change of plea is brought about by an agreement that's been negotiated by your attorney, Mr. Cooper. Is that correct?
Yes, sir.
Have you had the opportunity to discuss the terms of the agreement with your attorney?
Yes, sir.
And do you feel you understand the terms of the agreement?
Yes, sir.
And are you satisfied with the advice and the representation that Mr. Cooper's provided you?
Yes.
On the charges in case 2014-203, which are escape in the third degree, a Class C felony, and theft of property, a Class A misdemeanor, how do you now plead?
Guilty.
And in the case of 2014-137, where the allegations were that you had failed to report to your supervising officer on June 3rd of 2014, how do you now plead on that?
Guilty.
You're entering these pleas of guilty pursuant to this agreement that we've been talking about, and that agreement is set out in this document I'm holding up. That's called a plea statement. Have you read through this plea statement and signed it?
Yes, sir.
And you feel you understand what's set out?
Yes, sir.
You then understand the nature of the charges against you and the full range of penalties you're facing?
Yes, sir.
You understand the rights that you give up or surrender by pleading guilty?
Yes, sir.
In the case of the new and pending charges, you're giving up the right to a jury trial. You're giving up the right to be represented by an attorney and have the assistance of that attorney at trial. You're giving up the right to be to confront the witnesses that would appear and testify against you at trial. You're also giving up the right to appeal.
Yes, sir.
In the case of the revocation case, you're no longer entitled to a trial by jury for revocation, but you would be entitled to a hearing in front of the court. It would be a hearing at which the state would have the burden of proving that you had violated the terms and conditions of probation. At that hearing, you'd be entitled to be represented and assisted by an attorney. At that hearing, you'd be entitled to confront the witnesses that appeared against you. And at that hearing, after that hearing, you'd be entitled to appeal. All of those are rights you're giving up in this case. Do you understand? By pleading guilty, do you understand?
Yes, I do.
And understanding what you're giving up by pleading guilty, are you still willing to enter this plea of guilty?
Yes, sir.
Are you pleading guilty here today freely and voluntarily?
Yes, sir.
Has anybody in any form or fashion forced you into entering this plea?
No, sir.
As you plead guilty here today, do you acknowledge the truth of the accusations against you?
Yes, sir.
In the case of 2014-203, you acknowledge that on or about the 16th day of August 2014, you acknowledge that after being taken into custody on warrants, that you escaped from police custody and managed to take the officers on some kind of search for you, and I think you and took a motorcycle in the process of that.
I never got on a motorcycle, Your Honor. But I did escape from the handcuffs and the cop car.
When she was in custody in the back seat of the police car, policeman went to retrieve her belongings, and she got out the window and ran off.
Yes, that's correct.
I'm trying to get the facts for the misdemeanor theft allegation. She's admitted to the escape, but not.
Maybe the handcuffs, Your Honor.
Yeah, it's a handcuff.
Okay. So you escaped and taking the handcuffs with you?
Yes, sir.
All right.
Yes, sir.
I misunderstood that.
Okay.
All right. Based on that, and you also, in terms of the other case, do you acknowledge, as is alleged in the petition, that you had failed to report to your probation officer as ordered?
Yes, sir.
And of course, you are now admitting to having violated the law, which would be a separate violation of the terms and conditions of your probation.
Yes, sir.
Based on that, the court is going to accept the defendant's plea, find the defendant guilty, find the defendant has entered these pleas freely and voluntarily after consulting with an attorney and acknowledging and admitting to the facts constituting the crimes in each case. And on that basis, the court at this time formally finds the defendant guilty in case 2014-203 of escape in the third degree, Class C felony, and theft of property, a Class A misdemeanor. In that case, the court is sentencing the defendant to 90 days in the Baxter County Detention Center on the theft of property case, and to 3 years in the Arkansas Department of Corrections on the felony case. Those sentences will run concurrent. They'll also run concurrent with the revocation sentence in 2014-137, where the court is accepting the defendant's plea, finding the defendant to be in violation of the terms and conditions of probation, and revoking 3 years of her sentence, sentencing her to the Arkansas Department of Corrections. Those sentences will run concurrent with each other. The court is imposing in 2014-203 that the defendant pay court costs in the amount of $200, a fine of $1,000, there's a public defender assessment of $50, a public defender fee of $150, a statutory DNA fine of $250, and a booking administration fee of $20. At this time, the court's not fixing restitution. It apparently was to be determined, but I can't imagine. I can't imagine it to be very significant at this point.
$100,
And any fines, fees, costs, etc., that were ordered in the previous case, where she was placed on probation, that is in case 2014-137, the court is you'll still be obligated to pay those in accordance with the directions of this court. All of those obligations will be due and payable when you're released from the Department of Corrections become a condition of your parole. That'll be the order of the court. The court is remanding the defendant into the custody of the sheriff's office to await transportation to the Department of Corrections.